Businesses are seeking trusted sources of information to navigate the numerous challenges surrounding the rapidly evolving COVID-19 situation. The Greater Vancouver Board of Trade is bringing together a number of experts in various fields to act as a resource to our members and to the general public. I'm Bridget Anderson, the CEO of the Greater Vancouver Board of Trade, and I'm joined by Duncan McPherson, who's a partner at Bennett Jones, who deals with corporate and commercial law. And Duncan, thanks very much for joining me. I'd like to start off really looking at contractual obligations. A lot of companies are having to cancel events, supply chains are being impacted. What do companies need to know about force majeure clauses?
So many contracts, but not all, will have force majeure clauses. They are clauses that are frequently included in contracts, but often not used. So they're clauses that we don't actually, as practicing lawyers, come across every day in these types of circumstances. What a force majeure clause does is it excuses performance under the contract. And it is in effect meant to be a relief in extraordinary circumstances. And so as companies are considering and grappling with COVID-19 and wondering if they will be able to deliver on their contracts, I think the first thing to do is to read the contract, is to actually see what the force majeure clause says. And that's important because very often, force majeure clauses will speak to situations of disease or epidemic, but sometimes they won't. And sometimes they may speak more generally to circumstances that are beyond the control of the party. And so really you need to consider, does the force majeure clause apply in these circumstances? The basic test, the simple rule of thumb, is effectively performance of the contract needs to be impossible or near impossible. So circumstances that make performance more difficult or more expensive will typically not rise to the threshold of force majeure. And so you want to be cautious as a company when you're considering changing your performance, to really try and do what you can in the circumstances not to breach the contract. If you find that you really can't, given the circumstances, perform, then it's time to think seriously about giving a force majeure notice.
So there are public companies and private companies, and we have both in our membership. When it comes to those companies, though, that are public, that have requirements around disclosure, given this is a rapidly changing situation and companies are getting new information all the time, what do they need to know about disclosure?
So disclosure, as you say, is primarily a public company concern. We are in a disclosure season. I think the key points on disclosure are to consider the risk factors created by COVID-19 and to identify those risks in your upcoming public disclosure. In addition, because it's difficult at this moment to know what the overall financial impact will be, but financial disclosure is expected at this time, you would want to spend particular amount of time with your securities advisors, lawyers, on the forward-looking statements to ensure that you're not, that you're properly identifying the uncertainty and current financial predictions.
We are finding a lot of events are being canceled, whether they are small public events or larger public events, on the guidance of health officials. What about annual general meetings? What do companies need to know about holding annual public meetings or annual general meetings? And do they need to be in the public, or can they be over conference calls? Or what are some of the regulations and rules around that?
It's a very timely question. And I can say personally, our firm actually just changed its approach to annual general meetings as a result of COVID-19. Effectively, there are two approaches you can possibly take to avoid the typical in-person annual general meeting. The first is a hybrid the first is a virtual meeting. So actual shareholders meeting online, not meeting in person. And to be able to pursue that approach, you need to check the legislation that governs your company. Different legislation in Canada is more or less permissive when it comes to virtual meetings. In addition, you should check your bylaws or the constituting document.
And many of our members are small and medium enterprises, so they should be going back to their bylaws right now.
They should be. That's right. That's exactly right. If the statute and the bylaws allows it, then a virtual meeting is a possibility. It's important to bear in mind that the virtual meetings do need to use technology that allows shareholders to communicate. And I can't speak to that technology, but
up until fairly recently, it was sort of business as usual for many companies, and those organizations that might be involved in some M&A activity, well, the landscape has really changed in the last several days and continues to evolve. So what are the things to keep top of mind in those situations?
It's a very interesting, I think is the best word I can use, time for M&A. At the risk of stating the obvious, valuations may be affected by COVID-19. And so I think
rapidly changing.
And so in these types of circumstances, where deals have not yet been done, I think you'll see a lot of thought around valuations and potentially discussion around mechanisms that allow for price adjustments over time. Another circumstance that could be relevant is for deals that have been signed in recent weeks. And in those circumstances, it is hypothetically possible that buyers will not want to close the deal. And in that case, you really need to review the contract for the material adverse change clause. As a general rule, material adverse change clauses won't apply in circumstances of general changes in the economy. They would likely only apply in circumstances of a particular effect on a particular company. So a complex area that one should seek advice on, but it is certainly possible that the rapid change of last week will have an impact on ongoing deals.
Duncan, thank you very much.
Thank you.